Hello, and thank you for joining us. It seems a long time since, on the 14th of February this year, my colleagues Tim Worden, Matthew Royle and I presented a webinar on the issues raised by Brexit for the life sciences industry. Specifically, we spoke about those regulatory and exclusivity rights affecting medicines and medical devices, as well as issues raised for the EMA. At that time, Brexit negotiations had not yet begun, and the famous Article 50 had not even been triggered. Now, 9 months later, there have been 5 rounds of Brexit negotiations between the UK and the EU, with the parties apparently wide apart on the issue of how much money should be paid by the UK to the EU and for what. The Prime Minister, Theresa May, has intervened with a speech in Florence, offering concessions, including a payment of approximately 20 billion euros. But this has been deemed by the EU Council meeting on the 19th of October to be insufficient progress for talks to move on to our future trading relationship. Although the EU 27 have agreed to discuss future arrangements amongst themselves. Despite the reported lack of progress in the talks at the headline level, in this webinar we want to do 2 things. Firstly, we would like to recap very briefly on the key regulatory issues that are at stake in the Brexit process, focusing, as before, on medicines approvals, medical devices and the EMA. Secondly, we will discuss the activity there has been over the summer period and what that tells us about the regulatory relationship the UK government is seeking with the EU post-Brexit. In particular, there have been a number of recent papers issued by the UK government outlining their positions on matters that are relevant to medicines and medical devices. My name is Paul England, and I'm again joined by Taylor Wessing partners Matthew Royle and Tim Worden to explore all of these issues over the next 40 minutes or so. But before we begin, can I just ask you, as a matter of housekeeping, to please send us questions by email if you would like to, using the Q&A icon at the bottom of your screen. And please also do wait just after I've finished for a survey to appear, which the results of which we find very, very helpful for future webinars. So let's start by reviewing some of the relevant political background and steps that have been taken so far. As we reported back in February, the Prime Minister first outlined the UK government's Brexit objectives in her Lancaster House speech of the 17th of January, which were then reiterated in a government white paper on the 3rd of February. Since then, in addition to the triggering of Article 50, there's been a general election and a new government in the UK that commands only a slim majority with the support of the Democratic Unionist Party. As I said a moment ago, there have also been 5 rounds of negotiation between the UK and the EU, and an intervention by the British Prime Minister on the 22nd of September in her speech at Santa Maria Novella Church in Florence. As I'll also explain more about shortly, there have also been a number of relevant position papers and so-called future partnership papers published, as well as an important notice from the EMA. All of this flows, of course, from the instruction the government received to leave the European Union on the 23rd of June 2016. But there's a political context in the EU too. In simple terms, this could be described as the need to preserve the European project and discourage further anti-EU sentiment in the member states. At best, this means the EU cannot be seen to allow the UK a deal that is more attractive than EU membership. At worst, some have expressed the view that it means the UK needs to be punished. There is also a practical issue. The negotiations are conducted for the EU by the Commission, which is a bureaucratic organisation on behalf of 27 member state governments. So a number of different views on how the negotiations should be conducted and what should be achieved need to be harmonised. Although so far the EU 27 appear to be in full agreement about their strategy. Ratification will also be needed, as well as the approval of the EU Parliament for any deal. The result is an inherent difficulty with speed and flexibility. But on the positive side, there is a unique feature of the relationship between the UK and the EU. They start negotiations on future trade with exactly the same regulations and standards as each other. This is highly significant for the life sciences, as we will discuss. Now, before looking at the current position of the UK and EU in more detail, let's just briefly remind ourselves of what those issues are. For that, I'm going to hand over to Matthew Royle. Matthew.
Thanks, Paul. First of all, it's important to bear in mind that there is a difference between EU directives and EU regulations. A regulation is a legislative instrument that has direct effect. Now, this means that it is automatically applicable in all EU member states without the need for national implementing legislation. Directives, on the other hand, are legislative instruments setting out harmonising standards for national law. Directives do not themselves have direct effect and so must be enacted nationally in order to take effect in a member state. As a result, the effect of leaving the EU on the applicability of regulations to the UK is different to directives, which, as I've explained, have already been implemented into UK law. After the UK leaves the EU, regulations will cease to have legal force in the UK. If rights afforded by regulations are to be continued after Brexit, and the UK is to avoid a regulatory cliff edge, they must be replaced in UK law before the 2-year exit period runs out. It is for this reason that on the 13th of July this year, the UK government introduced the Repeal Bill, which is formally known as the European Union Withdrawal Bill. The Act that follows the bill will implement into UK law all of those EU laws necessary to ensure continuity in the immediate term from the day that the UK exit takes effect. This includes all the regulations that currently have direct effect in the UK. The bill is currently awaiting the committee stage in the House of Commons and is being held up by a very large number of proposed amendments. It must be enacted before the UK leaves the EU in March 2019, and in order to avoid the cliff edge exit, and it is a sort of a political test for the current government whether it can achieve this or not. However, the repeal bill is not enough in itself to avoid the cliff edge. More than this is needed to ensure continuity of the existing system, as we will explain in the next slides. Firstly, more is needed in relation to marketing authorisations. This is because there are 3 routes to an authorisation to obtain an authorisation for a medicinal product in the EU, and these require a degree of cooperation between regulators. Let's look briefly at these again. The first is the centralised procedure, which is governed by Regulation 726 of 2004. This procedure allows applicants to obtain a marketing authorisation that is binding in all European Economic Area or EEA member states, and that includes the EU member states. Applications for central marketing authorisations are made directly to and evaluated by the European Medicines Agency, or the EMA, which we will discuss in more detail later on. Then there is the mutual recognition procedure, which is set out in Directive 2001/83. The mutual recognition procedure is used for medicines that have already received an authorisation in one EEA member state at the time of the application. This is the so-called reference member state. Subject to objections on the basis of serious harm to public health, the marketing authorisation that's granted must be recognised by other member states. The third procedure is the decentralised procedure, which is also set out in Directive 2001/83. Like mutual recognition, it relies on the recognition by national authorities of a first assessment performed in one member state, again called the reference member state. However, unlike mutual recognition, the decentralised procedure is used for the authorisation of medicines which have not received a marketing authorisation at the time of the application. So for each of these routes, there is some element of mutual recognition cooperation necessary between member states and, in the case of centralised applications, the EMA. In order for them to carry on after March 2019, it will require more than the UK unilaterally implementing regulations into UK law. A measure of agreement will be needed between the UK and the remaining EU 27. And it's not just marketing authorisations that are at issue, because flowing from marketing authorisations are various forms of data and market exclusivity which apply to the authorised product. These protections are currently enshrined in EU law and will need to be considered alongside marketing authorisations as the UK prepares to leave the EU. So in particular, there is the 8+2+1 regime. This is the 8-year data exclusivity period that applies to a new medicinal product upon authorisation, which is followed by a further 2 years of market exclusivity before a generic version of the authorised product can normally access the market. An additional 1 year period of marketing protection may also be obtained for a medicinal product when a new therapeutic indication of that product is authorised that has significant clinical benefit. In addition, there are other rights which provide additional periods of protection, such as orphan medicinal product exclusivity. If applicants are not to have to duplicate their marketing authorisations in both the UK and the EU, then the systems of cooperation under the mutual recognition and decentralised procedures will need to be continued after the overall withdrawal of the UK from EU law. Similar considerations apply to medicinal products authorised under the centralised procedure. The key difference in respect of these products is that authorisation is administered by the EMA and approved by the European Commission. Post-Brexit, the UK would need to have legislation in place to recognise marketing authorisations and the consequent data and market exclusivity periods obtained through this procedure, or require its own separate approval process. To deal with medical devices and how the UK government plans to deal with these issues, I'll hand over to Tim.
Thank you, Matt. So as regards medical devices, 2 European regulations concerning medical devices and in vitro diagnostic medical devices, respectively, are now in force in the EU, including the UK. So the MDR will not apply until 3 years after entry into force, so their main medical devices regulation, and the IVD medical device regulation until 5 years after coming into force. These regulations are intended to fully harmonise the member states and tighten the regulation of medical devices, including strengthening supervision by member states and the right for notified bodies to make unannounced audits and inspections. Having come into force, the government has confirmed that the provisions of these regulations will continue in UK legislation from the first day of Brexit in 2019. However, the new regulations also provide for specific EU-wide infrastructure to be put in place, such as the UDAMED database of unique identifying numbers for devices, and the right of the Commission to issue common device specifications. In particular, any medical device manufacturer will want to be able to place their CE mark device on the UK market and the EU market without going through separate procedures and the use of separate notified bodies. So let me explain what happens if there's no cooperation on all these issues and what the UK government is currently saying about this. Taking all of these issues into account, it is clear that there would be a benefit in an agreement by which the UK continues to participate in the centralised procedure, MRP, and the DCP procedures at the pan-European level. These will require cooperation and mutual recognition between the UK and the EU/EEA member states. Similarly, much depends on whether agreement can be reached on the mutual recognition of medical device CE marks post-Brexit. A continuing relationship of the current kind would require cooperation between the EMA and the national authorities to be maintained, and is inconsistent with a no-deal end to the Brexit negotiations. Consequences of no agreement in the area of medicines are set out in the European Commission's and EMA's summary in their Q&A document, published on the 31st of May this year. and a parallel list of requirements relevant to nationally authorised medicinal products through the mutual recognition procedure and decentralised procedure published by the Coordination Group for Mutual Recognition and Decentralised Procedures, the CMDH as it's known. These documents set out the requirements of the directive and the regulation for MA holders and manufacturers importing from the UK into the EU on the basis that after Brexit the UK will be defined as a third country. The requirements listed include the transfer of MAs to holders established in the EU or EEA, authorisation or certification of UK-based manufacturers of active ingredient and finished product in order to import into the EU, the location of batch control and release sites to be situated within the EU, and the location of qualified persons in the EU. So, if no cooperation and mutual recognition agreement can be reached, the probable outcome is that the UK would reciprocate the measures set out in these documents by asking EU-based pharmaceutical companies to comply with precisely the same requirements in respect of the UK. Will an agreement be struck? Well, despite current political appearances, there's no reason to believe that a negotiated solution will be reached in which the efficiencies of the current systems are maintained. Sorry, there is reason to be more optimistic that a negotiated solution will be reached in which the efficiencies of the current systems are maintained in the life sciences sector. This is not only because such a scenario would benefit the EU and consumers as well as the UK. It's also because, as Paul said earlier, the starting point is that the UK and EU have all the necessary structures and regulations already in place. Official publications and statements from the UK government clearly indicate that this is the aim. So the first announcement of the government's intentions in this area came in a joint public statement made on the 4th of July 2017. In this, the Secretary of State for Health, Jeremy Hunt, and the Secretary of State for Business, Energy and Industrial Strategy, Greg Clark, made clear that the government wants to retain a close working partnership in respect of medicines regulation after Brexit, implying the continuation of some form of the current system. This is consistent with the Prime Minister's Lancaster House speech and the government white paper that Paul mentioned, which refer to the need to maintain certain areas of regulation. There is more on what a close working partnership might mean in a paper published by the UK government on the 21st of August, entitled Continuity and Availability of Goods for the EU and the UK, a position paper. The Availability of Goods paper is intended as a starting point, the beginning for negotiations between the UK and the EU on the UK's exit and future trade relations with the EU, not a full and final position. This paper sets out the government's desire to ensure the continued availability of goods in the EU and the UK after Brexit, and this would include medicines and medical devices. In an apparent rebuttal of the presumptions made in the Commission's Q&A document, the 21st of August paper states that it makes sense to recognise our common regulatory systems and the UK's ambition for cooperation in the future. What this means for products is set out in a number of principles of direct relevance to medicinal products and medical devices. Firstly, goods placed on the single market before exit should continue to circulate freely in the UK and the EU without additional requirements or restrictions. This includes, but is not necessarily limited to, A, ensuring there are no requirements to change labelling for these products, B, recognising the validity of approvals, registrations and authorisations issued for these products, and C, where there is a requirement to have a person responsible for compliance with particular product regulations based in the EU. An example is given of an authorised representative for a medical device. That person should be able to continue carrying out that responsibility for products placed on the market prior to exit, whether based in the EU or in the UK. There should be no requirement to relocate. Secondly, where businesses have undertaken compliance activities prior to exit day, they should not be required to duplicate those activities in order to place goods on the UK and the EU market after exit. To achieve this, the paper states that compliance should be recognised for both the UK and EU markets regardless of where the activity took place. One example given of such activity is the re-inspection of approved manufacturing plants. The paper also proposes that testing and batch release by qualified persons should continue in the same country of location post-Brexit. That is, separate qualified persons should not be required in the UK and the EU. Thirdly, the agreement should facilitate the continued oversight of goods. The paper cites, as examples, requirements on MA holders to report adverse events to medicines in relation to medicines. The paper suggests that agreement between the UK and the EU should stipulate, amongst other measures, that assessment bodies should be continue to be recognised in full and to fulfil any ongoing obligations for the lifetime of the products concerned, and there should be ongoing data exchange where currently provided for. This position paper largely emphasises the approach the government wants to take to products with existing authorisations. However, the reference to the UK's ambition for cooperation in the future clearly suggests that it also has future arrangements in mind. This position is broadly supported by a later paper, dated 7th of September, entitled Collaboration on Science and Innovation, a Future Partnership paper. This paper is largely focused on proposals for UK participation in future medical research, amongst other areas of science, as well as reiterating the government's intention to underwrite 2020 funding. However, the paper also alludes to the UK's commitment to a close working relationship with the EMA on medical regulation. The suggestion is, again, that the government envisages continued participation between the MHRA and the EMA. So, it might be thought that agreement on these matters is a matter of common sense, but this is to ignore a further issue on which more ideological considerations are relevant. This is addressed in another paper, dated the 23rd of August, titled Enforcement and Dispute Resolution, a Future Partnership paper. This paper does not refer to medicines regulation specifically. There are aspects of the paper, however, that implicitly envisage agreement on mutual recognition of authorisations and related measures between the UK and the EU. This is apparent in the paper's reference to the problem of divergence. The UK and the EU agree cooperation and mutual recognition of MAs granted in their territories. The regulatory law on which they are based must remain identical. If, however, the UK Supreme Court makes the ultimate decisions about how this law applies in the UK, and the CJEU does the same for the EU, it is inevitable that they will at some point make different decisions and the law will diverge. The suggested solution to the problem of divergence is the use of a single decision-making body with authority over both parties. In her Lancaster House speech of 17th of January, the British Prime Minister stated that this body cannot be the CJEU, and this has remained her position. The dispute resolution paper therefore suggests a number of precedents for other dispute resolution bodies, although it appears to be seeking a bespoke body rather than any of the examples given. One plausible way of achieving this is the use of a joint panel of senior UK and EU judges to make such decisions. That would apparently be acceptable to Brexiteers and the UK government. It may not be politically acceptable to some in the Commission and the EU Parliament. Assuming, however, for the time being, that agreement on the above issues could be reached, there is a more practical problem likely to be encountered by businesses marketing medicines and devices in Europe. This is caused by the separation of the Brexit negotiation process into a stage addressing exit issues, followed by a stage addressing concerning future trade issues. The regulatory issues discussed above can only realistically be resolved by discussing both at the same time, because questions arise both on how existing MA rights should be dealt with and how the process might work going forward. However, so far, the EU Council has resolved not to progress with the second stage because sufficient progress has not been made on the question of money. For its part, the UK government has suggested that no payment of money will be agreed until the very end of the negotiating process. There's a strong possibility, therefore, that all of the above issues, legal and financial, will not be agreed until the very end of negotiations. The next indication we will have of any breakthrough on the issue will be when the EU Council meets again in December. Here it will again decide whether sufficient progress has been made, although some commentators believe that the start of trade preparations internally in the EU suggest it will. All of this leaves businesses asking whether they should prepare for the duplication of activity implied by a no-deal scenario, or whether they should wait. One way in which that problem might be alleviated is a transitional period after exit day to allow for the details of a future trade deal to be resolved. Indeed, the idea of maintaining the regulatory status quo for no more than 2 years was raised by the Prime Minister in her Florence speech. Notably, since then, the Commission has talked about a possible 20-month transition period until 2020 because of its alignment with the budgetary period. However, this is another matter that will need to be agreed, and presumably this will also only be possible after sufficient progress is made on the terms of exit. Meanwhile, the Prime Minister stated for the first time on the 4th of October that the government is preparing for every eventuality, meaning that it is readying the country for a no-deal possibility. The Prime Minister also hinted in the House of Commons on 24th of October that unless a trade deal is agreed and outlined by summer 2018, there will be no transitional period because there will be no deal to elaborate and implement. So, while the emerging clarity on the UK's position is encouraging, there seems to be a long way to go before businesses can have any certainty on what the future will bring and are able properly to plan for it. There is another separate issue which has been running in parallel to this, which does not appear to be up for negotiation. That is the location of the European Medicines Agency. Matt is going to update us on the latest about that.
Yes, Tim. This is important because the EMA is the European Union body which, as I explained earlier, evaluates and authorises medicinal products within the European Union and the EEA, as well as administering marketing authorisation applications for conventional pharmaceuticals that have the option of using the centralised procedure. It is the compulsory route for new active ingredients indicated for various diseases, and also for certain classes of products, including advanced therapy medicines, biological medicines, and orphan drugs. The EMA was established by Regulation 2309 of 93 and superseded by Regulation 76 of 2004. However, neither of these regulations stipulates the location of the EMA headquarters, which is currently housed in London's Canary Wharf. There is therefore no rule actually stating that the EMA must physically be located in an EU member state. Instead, it has been taken as a political point of principle for the EU Commission that the EMA must be relocated to within the EU after the UK leaves the EU. At present, competition for a new host city in the EU is underway between 19 member states, including Copenhagen, Amsterdam, Milan, Stockholm, Barcelona and Dublin. Objective criteria for making a decision on where the EMA moves to have been set out, and the successful city will be announced on the 20th of November this year. However, the decision will not be easy, with the competing interests of 19 different member states to consider, and so the decision is likely to have a political element to it. In addition to the political difficulties, there are potentially practical problems facing relocation, particularly the continuation of the EMA's fundamental role of granting marketing authorisations. And it is this aspect that is causing concern within the industry. The European Federation of Pharmaceutical Industries and Associations, FPA, stated earlier this year in an open letter that it is a stark and alarming reality that such fundamental activities would undoubtedly be impeded were the operations of the agency to be disrupted as a result of the UK's exit from the European Union. In the event of obstruction or failure, Europe possesses no backup option. So a large part of this concern is caused by the issue of relocating the EMA's secretariat of 890 staff. A report of a new survey conducted by the EMA in anticipation of its relocation post-Brexit was published on 26 September. This report suggests that for 65% of the EMA staff, the new location will be a determining factor in their decision of whether to relocate or not. Goes without saying that the number of staff that choose to move will have implications on the functioning of the EMA and for business continuity. When asked about the most popular 5 candidate cities, which are actually not named in the survey, so we're left to guess which ones those are. EMA staff responses indicated that a staff retention rate of between 65 and 81% would be achieved on relocation. The survey states that the expected impact of moving the EMA, depending on the extent of specific staff loss, is that approval of new medicines and safety monitoring will largely be maintained, but with the possibility of delays, and that progress on a number of public health initiatives, for example, support to initiatives on antimicrobial resistance for the elderly and cooperation with health technology assessment bodies, may move at a slower pace. The EMA estimates in the survey that it will take 2 to 3 years to return to the present capacity in the event of one of the 5 most popular cities being chosen. If a less popular city is chosen, and therefore one assumes the staff retention rate reduces, greater business continuity impacts will occur, and this will lead to longer recovery times to get the EMA back to its present capacity. This survey has been followed by the publication of an EMA business continuity plan, which describes the EMA's methodology for prioritising its activities according to their impact on public health and the agency's ability to function, and how it plans to reallocate resources to its core activities after it has moved. In addition, financial difficulty will be caused by the absence of a break clause in the EMA's current lease, meaning that relinquishing its premises in London will potentially leave the EMA with a commitment to pay 20 years' worth of rent and associated charges, which is an estimated €400 million. Overall, the total bill for relocation is currently put at €500 million. So, moving the EMA is expensive and potentially disruptive to its core activities. Can any of this disruption be avoided? As I mentioned earlier, there is no legal reason why the EMA has to move. Indeed, there was a suggestion by David Davis, who you probably know is the Secretary of State in the UK responsible for Brexit, that there might be an opportunity for pragmatism to overcome politics on this issue, and that the EMA's location would be subject to exit negotiations. However, this looks an unrealistic proposition politically, particularly given the progress on selecting a new site for the EMA by the Commission. It would be very difficult for the Commission at this stage to back down on the EMA relocation issue, and the most likely outcome is that it will begin its move in March 2019, whatever the cost. And so disruption or potential disruption to the EMA's activities cannot now be avoided. So back to Paul to pull everything together.
Thank you very much, Matt. So yes, where does all this leave us? Well, predicting the outcome of negotiations remains difficult at this stage, of course. Nonetheless, as Matt and Tim have explained, in the area of regulation of life sciences products, we can at least outline the legal parameters and the broad alternatives. One possibility is that the UK does not get the continuing cooperation and mutual recognition in the area of medicines and devices that it clearly wants. Indeed, it's a possibility at the moment that differences over the financial settlement as a means to progress the trade talks mean the UK will leave the EU with no deal at all. Other highly political issues, such as the role of the CJEU, may also prove difficult to resolve. As we noted earlier, the UK government is preparing for this possibility. In this situation, the UK's enactment of existing European legislation using the European Union Withdrawal Act leads to the need for separate authorisations and associated measures for access to the UK and EU markets, albeit under identical legislation. But the ideal result for businesses, and let's not forget consumers too, in the UK and the EU is, of course, something close to continuity with the existing system regarding medicinal product authorisations and exclusivity periods, as well as the authorisation of medical devices. Taking all of these points into account, it should be obvious to both parties that there's a benefit for applicants, regulators and consumers in a cooperation and mutual recognition agreement for medicines and devices after Brexit. But it will all come down to politics and money, with a large element of brinkmanship added, no doubt. So that concludes this update webinar on Brexit, but we will be back in due course with further developments as the negotiation process unfolds over the next year. It remains for me to thank you for joining us, and also to tell you that we'll get back to you with questions, something I should have mentioned at the beginning. We'll reply to you personally on your questions, and thanks for sending them in. And we'd also ask you to hold on for a few moments again just to answer a short feedback form. Thank you very much and goodbye.